this is cause number CR 25-49, State versus Karen Marie Kirby. We're set for pretrial today. Mr. Weiner, go ahead.
Yes, I recently received a discovery in this case. It is a drug case, but there's some complex things surrounding the case that I'm looking into. Still need some time to review the discovery. I spoke with the state and they're not opposed to us carrying the pretrial forward to August if the court will allow.
Any objection from the state?
None, Your Honor. Thank you.
All right, court will reset Ms. Kirby for pretrial. Got a couple dates. I've got 12th, 14th, or 26th.
Let me look at the 26th, Judge. Thank you. Actually, I'm already going to be here on the 14th, so let's do the 14th. That's okay.
Okay. Court sets Ms. Kirby then for an additional pretrial August 14th at 9 a.m. All right, court has also asked the pretrial release department to drug test Ms. Kirby as a condition of her pretrial release conditions. Ms. Byrne, it has been, and who conducted the test? All right, and what were the results of the test?
The incident showed positive for cocaine and marijuana.
Cocaine and marijuana. All right. Mr. Weiner, do you want Officer Machuro sworn in and be able to ask her some questions?
I don't see any reason to do that, Judge.
Okay.
Is it the court's policy to send these off for confirmation?
I'm sorry, say that again.
Is it your policy to send these off for confirmation?
If requested. It's not my policy. I believe the probation department has a policy. If
Okay.
if it's denied, if the substance test is denied, then the court would send that off if requested. If it's not denied, then I wouldn't.
Understood.
Is there a request to send it off for confirmation?
I would request that. My client admits to smoking marijuana last week. Was very surprised by the allegation of cocaine, but I also explained to my client that these days people put a lot of different things in marijuana, and that might be how that came to be. So if we could have it sent off for confirmation, I'd appreciate it.
Okay. Court will order the probation department, pretrial release department to send the substance test off for confirmation of the result of the cocaine. All right, Ms. Kirby, the court's going to find that you have violated the terms and conditions of your pretrial release. The court's going to find your bail to be insufficient at this time. The court's going to place you back in custody for that violation.
What is her new bond going to be set at, Judge?
It's the court's policy to double the original bond posted. I believe our original bond posted was 50,000. So our new bond will be 100,000.
Thank you. Okay. Judge, that concludes my business. May I be excused?
Yes, thank you, Mr. Weiner.
Thank you.
Good to see you.
Yes, sir.
Schmidt, are you and Ms. Earlston ready? Yes. All right, court calls Ashley Earlston on conditions of pretrial release, allegation of non-compliance. This is an unindicted case. Court finds that this court issued the conditions of pretrial release on September 16th, 2024. All right, any announcements from the state?
Your Honor, the state does, it appears that we have the whole case. I don't know exactly when it was received by our office, but it is waiting for presentation to the grand jury. Unfortunately, that's the only update that I can give the court as far as the unindicted charge goes. If the court would like, I can try and make some phone calls and see if there's been any other review of it.
No, I'm more concerned about the allegation that she's been arrested while on conditions of pretrial release, waiting for that indictment of that cause. The pretrial release department has alerted the court that Ms. Earlston was arrested for either possession of a controlled substance or manufacture delivery of a controlled substance, I believe in Waller County, during the pendency of this case.
Yes, Your Honor, and looking at the incident report from that offense, we don't have much information given yet. And unfortunately, we were unable to follow up with Waller County at this point to try and get a more accurate picture of what Ms. Earlston's alleged involvement would be. So at this point, Your Honor, unfortunately, the only thing that we're aware of is the arrest. But we don't have a lot of details ourselves yet.
Mr. Schmidt, any announcements?
Well, Judge, Ms. Earlston's been on pretrial release on an unindicted case since, it says December 12th. The arrest in Van Zandt County was back in September, so we're getting close to a year since her arrest. As far as her pretrial release conditions are concerned, I spoke with Mr. West, and other than this allegation, she has had no violations. She volunteered a urinalysis this morning, which was negative as well. I would ask that the court continue this matter and see if we can't get the actual allegation here on the docket eventually so that we can tend to that. But so far as I can tell, based on Mr. West, this is the only allegation of any violations. And obviously she would have a defense to that as well.
Anything further from state?
Nothing further from the state, Your Honor.
Anything further from the defense?
No, sir.
All right, court, having received the information from the pretrial release department, it appears that Ms. Earlston, having been arrested in Waller County for the alleged offense of manufacture, delivery of a controlled substance in penalty group 1B, greater than 4 grams, less than 200 grams on April 23rd, 2025. Court finding that Ms. Earlston is on conditions of pretrial release in this court. Court takes judicial notice that upon her arrest, a finding of probable cause was made to believe that she had committed that offense. Court is going to find at this time that her bail in this case is insufficient. Court is going to order her back into custody. The court will set new bail. So we'll go ahead and take Ms. Earlston into custody, and I will provide an order for her commitment and setting of new bail. I'm not sure what that is yet, Mr. Schmidt, but I'll provide that to you when I get it. And if there's a request to put her on some type of hearing docket, then notify the court and we'll get it set.
Yes, sir.
Well, that took a turn. This session featured 2 defendants, both on pretrial release, both facing tough conversations about substance use, and both ultimately taken into custody by the end of their hearings. First up was Karen Marie Kirby, whose attorney, Mr. Ryan, had just received discovery and was requesting more time to prepare. The court was willing to accommodate, and everything seemed to be cruising along until the judge called for a drug test report. That's when things got serious. The results came back positive for both marijuana and cocaine. Mr. Ryan didn't dispute the marijuana, his client admitted to that, but raised concern over the cocaine, suggesting it may have been an unintended consequence of tainted marijuana. Fair point, and he requested confirmation testing. The court agreed to send the sample off for verification, but Judge Martin made it clear, violation is a violation. Citing court policy, he found her original $50,000 bond insufficient and doubled it to $100,000. Miss Kirby was taken back into custody then and there. It was a sharp pivot from what had started as a routine pretrial reset. Then came the case of Ashley Earlston, another defendant out on pretrial release, this time with a pending indictment. Her matter involved an alleged arrest in Waller County for manufacturing or delivering a controlled substance. And though the state admitted they didn't have much detail beyond the arrest itself, the pretrial release department had flagged it. Her defense attorney pointed out that Miss Earlston had otherwise complied fully with her conditions and even voluntarily submitted a clean urine sample that morning. Still, Judge Martin reviewed the arrest date, the probable cause finding, and concluded that her current bond was insufficient as well. With that, Miss Earlston, like Kirby before her, was ordered back into custody. Pending a new bond decision, Judge Martin was composed and procedural throughout both cases, never flustered, never harsh, but unwavering. His handling of both matters was a firm reminder that pretrial release is a privilege, not a guarantee, and that conditions, especially those involving substance use, are taken seriously. Even when defendants had plausible explanations or had otherwise complied, the court held firm to its standards. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.